Alrighty, we have audio, we have video, we have control of the vertical and the horizontal. And we are reading from the book Modern American Remedies, as opposed to medieval American remedies, which were not a thing. Odin, gotta love that name, versus Chemung County Industrial Development Agency. Freaking bureaucrats versus Odin, come on now. New York 2nd District Court of Appeals, 1995. Titone is the judge. The present action arises out of a December 1988 incident in which a plaintiff, a 48-year-old ironworker, was injured when he was struck by a falling steel column that was apparently dislodged by a small hydraulic crane. Goodness gracious. Following a bifurcated jury trial, meaning there's the liabilities determined in one part and then the amount of damages in the second part, bifurcated, fractured into two parts. The plaintiff was awarded damages as followed: $5,752.75 for past medical expenses, $20,000 for pain and suffering, $27,555 for lost past earnings, and $66,000 for lost pension benefits, and $80,000 for future lost earnings and health and welfare benefits. Following a hearing pursuant to New York CLPR Section 4545C, the court ordered that the total award for future economic loss of $146,000 be reduced by $141,330, the value of the disability retirement benefits the plaintiff expected to receive over his lifetime. On plaintiff's appeal, the appellate division modified by restoring the full amount of the $80,000 award for future lost earnings and benefits and adjusting the total damages award upward accordingly. That was heard in the appellate division of the 2nd District of New York in 95. The court impliedly determined that only the award for lost pension benefits was sufficiently related to the collateral disability retirement benefits to qualify for the offset permitted by 4545C of the New York Code. Under traditional common law principles, a personal injury award may not be reduced or offset by the amount of any compensation that the injured person may receive from a source other than the tortfeasor. So other than the people who did the bad, that hurt the guy, that caused the injury, the monetary damages can't be offset by any other source other than income he would have received from the company that was in charge that hurt him. The collateral source rule, which is both a rule of evidence and a rule of damages, is based on the premise that a negligent defendant should not, in fairness, be permitted to reduce its liability by the proceeds of insurance or of some other source to which the defendant has not contributed. Although the rule has been criticized, it was not modified or curtailed by the courts of the state, meaning it still is what it is, even if you don't like it. The rule was limited by the legislature. The statute applies to any chain or claim for damages for personal injury, injury to property, or wrongful death, where the plaintiff seeks to recover for the cost of medical care, dental care, custodial care, or rehabilitation services, loss of earnings, or other economic losses. The issue is not entrusted to juries. Compensation from collateral sources is to be deducted from damages by the court. Quote, if the court finds that any such cost or expense was or will, within reasonable certainty, be replaced or indemnified from any collateral source, it shall then reduce the amount of the award by such a finding. This was Section 4545C in 1995. It has since been relettered as 4545A in 1998. Well, what do you know? Relying on its view of the language and the purposes of the statute, the appellant argues that 4545C requires the court to reduce the total award for economic loss by the total amount of collateral source payments for economic loss the plaintiff has or will receive as a result of the incident that led to the lawsuit. In contrast, the plaintiff contends that the award for economic loss should be broken down into categories, and the reductions for collateral source payments should then be made only in those categories that correspond to analogous collateral source categories. We conclude the plaintiff has the better of the argument. Well, thank God he does. We note at the outset that 4545C is a statute enacted in derogation of the common law, and as such, it is to be strictly construed. Quote, rules of the common law must be held no further abrogated than the clear import of language used in statutory absolute requires. that was both British and Swedish, and I'm not even sure. New York Statutory Law, Section 301 Bravo. These principles and a close analysis of the statutory text provide support for the plaintiff's position. The statute first refers to actions to recover for enumerated and other economic losses, and then authorizes the trial court to consider that any such losses were or will be replaced by a collateral source. The use of the term quote unquote such unquote, which serves as a grammatical echo for its immediate antecedent, suggests that a direct correspondence between the item of loss and the type of collateral reimbursement must exist before the required statutory offset may be made. The statute's provision for the offset of, quote, any such cost or expense, close quote, by a payment from, quote, any collateral source, close quote, emphasis added, does not contradict this conclusion. The statute's dual reference to, quote, any, unquote, cost or expense and, quote, any, unquote, collateral source was evidently a legislative effort to establish that, apart from the express statutory reservations, there are to be no limitations on the type of economic losses or the types of collateral benefits that the offset is intended to reach. Nothing in the use of that inclusive adjective negates the separate implication arising from the statute's other operative language that only those collateral source payments that actually replace a particular category of awarded economic loss may be used to reduce the injured judgment. The statutory requirement that the court make a finding that the award cost or expense, open quote, was or will be replaced or indemnified, in quote, emphasis added, from a collateral source belies the contention that the statute's juxtaposition of, open quote, any cost or expense, close quote, with, open quote, any collateral source, close quote, was intended as a direction to treat all collateral source payments as fungible. A disability annuity received as a result of out of his pocket medical expense the plaintiff incurred as a result of an accident related injury. The proposition that a payment from any collateral source replaces or indemnifies any accident-related cost or expense thus cannot be sustained. The correctness of this construction of the statute is also supported by the policy considerations underlying the common law collateral source rule and its recent legislative modifications. The chief criticism of the common law rule was that it permitted double recovery. While the resulting windfalls to plaintiffs were deemed a necessary and acceptable evil, the primary aim of tort law was to punish and deter wrongdoers. The collateral source rule doctrinal underpinnings were seriously eroded by the law's shift to focus considerably different goal of compensating injured individuals as opposed to punishing the bad guys. If just compensation is the main end toward which tort law is directed, it makes little sense to perpetuate a damages rule that tolerates two or more recoveries from the same injury. It was this perception, along with rising insurance costs, that motivated the legislature to take steps to modify the common law rule. The legislature's goal of eliminating plaintiffs' duplicative recoveries is served by subtracting the total award, those collateral source payments that duplicate or correspond to a particular item of economic loss. The broader rule that appellant advocates, which would mandate subtraction of all collateral source payments arising from the incident, regardless of whether they duplicate an award item of the pecuniary loss, would overcompensate and produce results beyond those necessary to remedy the evil at which the legislation was aimed. Indeed, the rule the appellant advances would confer an undeserved windfall on tort defendants and their insurers by permitting them to obtain credit for collateral source payments that they do not contribute to and they do not correspond to the economic loss that they are being called for to reimburse. In this instance, the appellant seeks to have the plaintiff's award reduced by the entire amount he's expected to realize from his disability retirement pension. However, contrary to the appellant's argument, the plaintiff's retirement pension benefits have not been shown to replace his lost future earnings and health and welfare benefits for which the jury awarded him $80,000. Rather, those benefits are paid in lieu of ordinary pension benefits and do not necessarily correspond to any future earning capacity plaintiff may have had. Indeed, it is undisputed that, notwithstanding his retirement as an iron worker, plaintiff would have been free to earn income from his labor in other capacities without loss of his disability retirement pension benefits. Thus, it cannot be said that the disability pension benefits plaintiff expects to receive are duplicative of the award he received for lost future earnings. Accordingly, the appellate division properly limited the operation of Section 4545C, in this case by applying plaintiff's anticipated $141,300 disability pension benefits to reduce to zero the $66,000 award for lost ordinary pension benefits was the disability pension benefits did in fact replace. That makes sense. We note that despite the appellant's expressed concerns about the practicality of requiring a close correspondence between collateral source payment and the item of pecuniary loss to be replaced, we see no insurmountable difficulties in establishing the necessary linkage in appropriate cases. CPLR section 4111F, which requires a detailed itemization of the elements included in the injuries damage award, will operate to facilitate this task. The problem of matching up a collateral source to an item of loss is simply a matter of proof and of factual analysis. The burden of establishing the requisite correspondence rests, of course, on the party seeking the 4545C offset. Or the burden is not sustained because the connection of the item of loss and the collateral source payment is tenuous, or because the necessary correspondence between the essential elements is lacking, the purpose of the statute would not be served by applying a mandatory offset. Accordingly, the order of the appellate division should be affirmed with costs. And there was a all concurring 5-panel decision. So there you have it, folks. More remedies tomorrow. Have a good night. Conflict of laws next. Dun dun dun.